There's a good few online now, so we'll start. Welcome to BCS, the Chartered Institute for IT. My name is Brian Runciman. I'm the Head of Content and Insight at BCS. We have webinars pretty much every fortnight on big issues. It doesn't come a lot bigger than the one we're discussing today, the impact of Brexit on the IT industry, on the sector in general. We've got three proper experts to speak to us today, slightly different to our normal perhaps debate scenario. What we're going to do is going to have little presentations from each speaker. So we've got Barrister Jane Lambert, who I'm going to hand over to in a moment. We've got Mark Derbyshire, CTO from SAP, and we've got Quan Hon, who's been with us before as well, who's a lawyer and an author as well. So I'm confident that we're going to get some interesting stuff today. I would say to you all, you're more than welcome. In fact, we'd encourage you to put questions into the chat. So I'm sure we all know how to do that now at Zoom. At the bottom in the Q&A, put comments in. We probably won't deal with them as we go through the presentations. That'll be about 25 minutes or so, maybe a little bit longer, but we'll start picking those up in the chat at the end. And the plan is to finish at about 1:15. So without further ado, let me hand over to Barrister Jane Lambert, who's going to do some scene setting for us. Jane.
Yes, thank you very much indeed. Good afternoon, ladies and gentlemen. I'm going to be talking about the legal background to the two deals, and I think the most important thing which I can say is that we talk about a deal, but there actually were two deals. There's the one which withdrew us from the European Union, and that's the one which contains most of the law, and that's contained in a treaty called the Agreement on the Withdrawal of the UK from the European Union and Euratom. And everybody calls it the withdrawal agreement. It's actually referred to that in the implementing statutes and referred to even in Article 53 before it was actually drafted. Then the agreement, which was entered into on the last day of the year, was arranging for our future relationship with the European Union. And that again is being implemented by legislation which required the House of Commons to sit on the 30th of January. Now, just a couple of things I'm going to be mentioning. The first is that excuse me. Oh, here we are, withdrawal agreement. As I say, that came into effect on the 31st of January, and it actually was the provision which has withdrawn us from the European Union. It's a very, very hefty document consisting of nearly 600 pages of text. The body isn't so long, it's about 185 articles, but there's a massive number of annexes and protocols. The important things to remember for the moment are that the agreement provided a sort of grace or implementation or transitional period, which lasted until 31st of December of last year, 11 o'clock, 31st December, where we're supposed to draw up a future relationship agreement. But it also was the opportunity for us to get used to the idea of trading under a different sort of legal framework, and it was an opportunity for the government to get its legal ducks in a row for when European Union law ceased to apply to us. Now, I'm not altogether sure that the government made full use of this opportunity, but that was the idea. The future relationship agreement, which is the next slide when I can get it down. I made these, I'm afraid, in PowerPoint, but I saved them in PDF. That basically provides for us to trade in goods, not services. It makes a number of other changes, some of which will impact on the computer industry. For example, law enforcement privacy will have an impact on privacy and so on. The important bit is part 2, which covers trade And it includes intellectual property, it includes data protection and various things like that. The rest of the agreement, which is again quite a hefty one, is in form of annexes and so on. I don't think for the purpose of this discussion we need to talk about it in detail. And it's been implemented by 3 acts of parliament, of which the most important is the European Union Withdrawal Act. And there are basically 2 provisions you need to know about. The first one is section 1, which repealed the European Communities Act, which is the legal underpinning for our joining the European Union in 1972. And the other was section 3 of the Act, which incorporated into English law all the regulations which had previously been issued by the Council of Ministers or the Commission. And so there wasn't a gaping hole when we left. Basically, ministers have the power to amend or to even repeal these community regulations if it thinks they're appropriate. And there's safeguards in the Act for parliamentary scrutiny to see if it's done, at least in theory, properly. There are a whole mass of statutory instruments which cover the whole. It's going to take far too long to go through even those on intellectual property, but basically government has relied very much on the regulations made under that act. The European Withdrawal Agreement Act just extended European law for to the end of this month. And the final thing I'm going to say is that as far as computing is concerned, our membership of the European Union did make a lot of differences. We actually had legislation which made it possible to protect with copyright computer software. We had the database regulation, had lots of other things. But most of these are going to be preserved one way or another in English law. So far as IP is concerned, which is my speciality, there won't be all that much change. And similarly, we're going to try and protect, to preserve something like the GDPR and other things. Parliament has provided that the case law has to be adhered to, though the Supreme Court can depart from it. That's all I want to say about the legal aspect of it, Mr. Chairman.
Thank you very much, Jane. Appreciate that introduction. We're going to now talk to, or Mark's going to talk to us, because he's very much a perspective from the sharp end. So over to Mark.
Thank you, Brian. Let me just put this into full screen. So I just wanted to talk briefly about the impact that maybe the Brexit deal and related changes in law have had on the IT sector and the function. And obviously, my perspective is that of it coming from SAP. And SAP is, I guess, in some industries are synonymous with the system that kind of runs the business. And I think that's borne out by some of the statistics that we have. Something like 78% of the world's financial transactions touch an SAP system. So for things like Brexit, we tend to find that our systems and our customers obviously get very, very deeply involved. So I wanted to break this up into sort of 3 areas. What's the impact? What was the response, both from our customers and the response that we heard, but also, you know, what might the future start to look like? From the terms of as just a sort of, you know, are we technically compliant? Are we ready? Where I would recommend people to start looking is at an SAP note, and there's a particular one, 2885225, that well-known SAP note, and that's really the starting point to go and start to explore how Brexit impacts the SAP systems that you have, where they run, the countries that you trade with, and so on. So this will cope with things like, how does the UK come out of the EU data model? How does it participate with other organizations? What does it now mean to do third country trading and so on like that? There's also, as you might well imagine, quite a lot of content around implementing something which was somewhat net new, I suppose, from a technological perspective, which was the Northern Ireland Protocol. How did we put that sort of in-country barrier in place, and what does that mean for your SAP systems if trade and things like that occur over that boundary? Again, lots and lots of detailed SAP notes on that. You don't need to log into anything to do that. You can go to notes.sap.com, type in the number, and away you go. There's also publicly available SAP blogs, which cover different people's perspectives of different parts of the journey that organizations might have to have undergone. And lastly, to reassure yourself of legality, we also have an SAP notification dashboard, again, very easy to get to and very publicly available, where you can filter down on what legal notices, for example, from things like SAP notes, are relevant to you and your business. So with all of that in place, and a lot of that has been in place from the middle of last year, many of our customers obviously embarked on the journey. And we would have meetings. I certainly was at meetings in October or November when suddenly someone would disappear because they've got to go and discuss Brexit. And so obviously, whether the company could talk about it or not, this is clearly a very important issue for everyone and something that everyone wanted to be on top of. We put out a range of ways of trying to garner some of that customer response. We had user group meetings. We had a Brexit website where people could fill in a survey and talk about it. Our CEO in the UK sent out a note to customers saying, you know, this is our perspective. We're here to support you. We also put together some simple FAQs about the sorts of questions that you might get, you know, the data questions about data flows and going over GDPR borders, Brexit readiness, what might be the impact of no deal, things like that, the standard sorts of questions that we'd expect. And we didn't really hear very much back from our customers, rightly or wrongly. I didn't interpret that as they don't love us. I interpreted it that as more that they were getting on with their business. And for a lot of organizations where their systems were directly affected, the SAP notes and the advice therein was sufficient for them to get comfortable about where they should be, which is perfect. But if you scratched a little bit deeper, you also saw, and we were seeing this come out in the news broadly, that people's workloads have changed. What used to be maybe 1% of their orders and an international third country trade has now become a large percentage of their orders. And so companies are now having to deal with new processes, new workloads. Because of some of the things that have happened maybe since Brexit, such as COVID, a lot more of the people that would have worked in the same office, and so you would have had process by proximity, people are now working remotely. And so that same coherent view of a customer's process or a production process, whatever it is, it's just not there. And that's forced people to start to adopt systems of record, very simple ones, you know, shared drives, email and things like that, to start to share that process. But it does quite often mean that the processes just get broken. And so whilst I don't hear many customers complaining about, oh, I can't be ready for Brexit, I do hear a lot of customers worrying about how do they address the new normal, as maybe they phrase it. And I think the last point in that is then how do you then start to scale? Some organizations have seen huge rises in the online traffic that goes to their websites, their stores, or their service bureaus. How do you accommodate that? So I think lastly for us, for SAP, what customers are asking us about now really is not, you know, what comes next, let's hope no other countries leave Europe or whatever. It's not, the focus isn't so much on Brexit or its repercussions. The focus is now on what do we do going forward, and what can we start to adopt to make our organizations, I suppose, more agile and maybe probably more pertinently, more resilient to whatever seismic business changes we see this year and we see next. So, you know, in a modern SAP landscape, it's not just about the ERP system. There's a whole set of systems that we provide. We provide supply chains and human resources systems. We provide customer experience, CRM, spend and supply chain management systems. All of these have been impacted in different ways. You just had to open the newspaper to see that all of these have been impacted in different ways at certain levels by Brexit. But it has meant that having these processes well-defined and well executed becomes even more important. But that sort of captures some of the aspects of the modern SAP platform. It's not just ERP, it's business applications, it's business networks, it's cloud-based applications, it's industry solutions, and it's a set of technologies that underpin that. And that's now where I find a lot of my customers are looking for some of the answers to how do they cope with Brexit and how do they perhaps cope with COVID, which is Let's have more insight so that we can better predict what might go wrong as our supply chains change. Let's have better collaboration so that we understand what's going on in an end-to-end process. Let's start to have some low-code apps and things like that so that we can start to return to that what we could previously do in the office. Or maybe those low-code apps give us better advice as to how to navigate websites that we now need to navigate for Brexit. So then I think there's a lot of stuff around automation, making automatic reports, having robotic process automation for simple tasks, standardizing your processes so that you don't have to worry about supporting them yourselves and the costs that go with that. But also data automation, being able to better feed the systems that then give you the insight, I think is a great opportunity now for customers and organizations throughout the UK to take advantage of this. That there's a net change in their business. You really need to understand that. You can't just see and just listen to the sole voices of the complaining. You need to understand the full depth into the pipeline. And that then leads lastly, I think, to business intelligence and probably to digital supply chains, as people now want to ensure that their businesses are resilient to whatever happens at borders and whatever happens within countries going forward. So I think for SAP, it's our customers, we got through quite happily, quite uneventfully, the Brexit transition, and it's now about how should our organizations readapt themselves and reorganize themselves to best address, I think, future seismic changes, of which I'm sure there will come. But for us, really, it's about looking to the future and understanding what can people do as first steps to start to improve their landscape and start to improve the productivity of their businesses. So that was really all I wanted to say from an SAP perspective. I don't know if that provokes many questions or not, but yeah, thanks for your time.
Thank you, Mark. That was very useful, vendor perspective. I appreciate that. In fact, I think there's going to be plenty of conversations to be had about ongoing transformation journeys, and perhaps we could pick one or two of those up if you've had that feedback from your customers that's being provoked a little bit more. Yeah, that'll be good. We've got some questions coming. We'll deal with them in our chat a little bit later on. First, we'd just like to hear from Kwan Hon, please. Kwan's spoken to us before, and when we did our Schrems webinar. This one's a slightly different angle, so over to you, please, Kwan.
Thanks very much, Brian. I'm just going to share my screen. Okay, everybody see that? Great, thank you. Right, well, there's quite a lot to get through on the data protection front. So there are some topics which I'll cover only if time. If I overrun, then Brian will let me know. Just a brief recap on the GDPR, because I know most of you aren't GDPR lawyers. GDPR regulates the processing of personal data of data subjects, individuals, not corporations, with tighter protections for special category data like health data, data on ethnicity, sexual orientation, and so on. And there are exemptions like processing for purely personal or household purposes, and processing is very broad, so pretty much everything that you can do with or to electronic personal data is going to be considered processing. Now, of course, the EU, sorry, I've skipped over one. Yes, the regulation bites on those who are controllers and processors. Controllers who control the purposes and means of processing personal data have most of the obligations, but processors who can be engaged by controllers to help them process personal data also have obligations under the GDPR. Just remember, there is a difference between licensing software and providing services like SaaS in terms of what the role of those organizations are, controller, processor, etc. And be careful about processing within groups of companies, because technically groups of companies consist of different legal entities who are considered different persons under law. So don't think, oh, well, it's just one group, it doesn't matter, because within one group, you can have one company, which is a processor, for another company that is a controller within the same group. The GDPR is, of course, regulated by supervisory authorities like the Information Commissioner's Office, ICO, here in the UK. And the European Data Protection Board, or EDPB, also has a role in promoting consistency, in providing guidance and certain other issues, dispute resolution between regulators. Now, of course, the UK is now no longer a member of the EEA, but we still have what's called the UK GDPR under the UK Data Protection Act 2018. So that still applies. At the moment, it's pretty much the same as the EU GDPR. One important area to mention is territorial scope. When does the GDPR or the UK GDPR bite on certain processing? And basically, there's two main grounds. The first is if you have an establishment in the EEA or UK respectively, like a branch or a subsidiary, and the processing that you're considering is of personal data in the context of activities of that establishment, then you are caught by the GDPR, or that processing is caught by the GDPR. And this is a really, really broad concept. In the Google Spain case, which predated the GDPR, but the same is going to apply. It was under the predecessor legislation for the GDPR. Google in the US was held directly subject to the Data Protection Directive. It had a Spanish marketing subsidiary, but the activities were directly related to Google's search engine and advertising activities. And if you are caught under this establishment head, then the GDPR, or UK GDPR, as the case may be, will apply to all that processing, regardless of where those data subjects are located. So a UK establishment processing personal data in the context of its own activities would be subject to the UK GDPR, even if it's processing personal data about Australian data subjects or EEA data subjects. So this is really broad. Now, the second main head is where the processing of personal data is, quote unquote, related to, which is very broad again, two things. One is offering goods or services to EEA or UK residents respectively, or monitoring their behavior occurring in the EEA or UK respectively, including online behavior, so online tracking, analytics, that sort of thing. Now, the related to bit is really, really broad, and in guidance by the EDPB, which courts may or may not follow, we'll find out, they give the example of a US company which is selling to EU residents, and it hosts its e-commerce website on using a US cloud provider. And because the US cloud provider's processing, its hosting, is related to this offering, they said that the US cloud provider is subject to the GDPR under its territorial scope. This is really, really broad. And I think it's too broad because, you know, a hosting provider may not necessarily know whether its services are being used to host an e-commerce website to sell to the EU or the UK. But that's what the regulators have said. So there is a possible double exposure here, because you could have a UK establishment and therefore caught by the UK GDPR, but the UK establishment is selling to EU residents and therefore caught by the EU GDPR. So there's a possible double whammy here. There is an issue about enforcing against a non-EU or non-UK company, which I will say a bit more momentarily. So if there's an establishment in the EU or in the UK, then regulators can enforce against that establishment. If there isn't an establishment, if the processing is caught because it's related to offering goods or services or monitoring data subject behavior, the processing is still directly subject to the GDPR, but there's an additional requirement to appoint a local representative in one of the countries where the relevant data subjects are located, like, you know, those who are being sold to, etc. there are exemptions, so public authorities or bodies don't have to appoint a local representative. There's also an exemption for processing that's only occasional. It's not large-scale processing of special category or criminal data, unlikely to result in a risk. Well, that's a pretty narrow exemption because it's very rare that processing is unlikely to result in a risk to individuals. So that means in many cases, a representative will have to be appointed. So UK companies might have to appoint a representative in the EU. EU companies, or EEA, I should say, may have to appoint a representative in the UK, depending on what they're doing. And there is, again, this possibility of double fine in both the UK and the EU in this situation. Now, of course, the enforcement issue is a different matter, whether it can be enforced against those companies in practice. And interestingly, recently in Luxembourg, Max Schrems' NGO, NOYB, is appealing against decisions by the Luxembourg Data Protection Authority, who said, well, there isn't, these are US companies you're complaining about. They don't have a representative in the EU, so we can't enforce against them. So we're not gonna, we were dismissing the complaint, which is, an interesting approach because the NOYB would say that's against what the GDPR is trying to say. But then in practice, how do you enforce against somebody that you can't actually go against, in your country or in your region? Now, this, again, relatively recent news story is more general. It's about UK government departments telling UK businesses, well, because of Brexit, you might be better off if you set up in the EU outside the UK, or move to the EU outside the UK, which of course might mean the loss of British jobs. But that's what they've said. And from a data protection perspective, the angle is that there is something called the one-stop shop, whereby if you have a main establishment in a particular EU country, then you answer only or primarily to the regulator in that country, like the ICO here, rather than facing possible regulatory investigations and enforcement from regulators in all the member states for cross-border processing activities. And of course, now that the UK is no longer an EEA member state, those organizations which have a main establishment in the UK can't rely on the one-stop shop anymore, and they are exposed to regulatory action from all these possible regulators in all these different EU countries or EEA countries. So therefore, some like the EDPB has suggested that maybe UK companies should think about setting up a main establishment in another EU country like Ireland. So that is an issue, and some may or may not be doing this, but it's certainly something that a lot of companies are considering at this point. Another important area is to do with transfers or data exports. So just by way of recap, under the GDPR and UK GDPR, you cannot transfer personal data outside the relevant area to a so-called third country or international organization unless a derogation or exemption applies, like specific consent, or you use a mechanism that is recognized by the GDPR. For example, an adequacy decision by the Commission about a particular country or sector, such as the US Privacy Shield, which of course, as we all know, is now dead. Binding corporate rules or BCRs are another method allowed under the GDPR. And of course, another one which has been discussed a lot is SCCs, standard contractual clauses or model clauses, where post Schrems 2, you now have to have what I call SCCs plus. SCCs alone are not enough. It's necessary to take some further steps, some additional safeguards or supplementary measures. And these do particularly include technical measures like encryption, multi-party computation, and personally, I would advocate trusted execution environments, enclaves, confidential computing. I think those sorts of things will really help to allow transfers outside the EEA where possible, or the UK where possible. Now, remember, transfer is not defined in the GDPR, but it's a really broad term again. So it's not just sending personal data outside the EEA or the UK. It also includes hosting personal data outside, backing up personal data somewhere outside, allowing remote access by somebody who's outside that area to personal data that's hosted inside that area. And remember what I said before about groups of companies, even if you're sending personal data outside the EEA or UK to somebody who's in the same company or the same group of companies, that can still be a transfer. The ICO has a slightly different interpretation of what is a transfer here, which there's no time to go into, but generally consider whether any of this could be a transfer that's restricted under the GDPR. And of course, it's not just what mechanism do you use, how do you legitimize a transfer, but there are other issues like privacy notices covering transfers, processing records covering transfers, and so on. Oh, sorry, that's gone too far. Now, in terms of transfers from the UK, we have the UK GDPR that applies.
Quan, a couple of minutes now, Quan, please, if that's okay.
Okay, transfers from the UK to the EEA are allowed because the Data Protection Act says so, but if you need to get the data back, like you're hosting it with an EEA provider and then want to transfer it back, that's a different issue that has to be considered, which I'll come to. Transfers from the UK to other countries outside the EEA are okay if you use a currently recognized mechanism, and the law does provide for other ways to do this, like Secretary of State regulations, clauses approved by the ICO, codes of conduct, etc. But there's nothing yet. Transfers to the UK from the EEA, that's under the GDPR. Now, the Trade and Cooperation Agreement that Jane mentioned, the TCA, provides for a bridging period. So the UK is not considered to be a third country, so you can transfer from the EEA to the UK, as long as basically the UK doesn't mess with existing data protection law and transfer mechanisms during that period. This bridging period is for 4 months, extended to 6 unless the EU or the UK objects, or if earlier the UK gets adequacy. So we're talking about 30th June 2021 at the latest. What if the UK doesn't get adequacy? The ICO says take sensible precautions. The UK government seems very confident that we will get adequacy. I just wanted to briefly mention the e-privacy directive, which is so-called lex specialis to the Data Protection Directive, the GDPR's predecessor. And this is meant to particularize the application of data protection rules to a particular sector or type of processing. And it's the source of the infamous cookie law, implemented in the UK under the unfortunately acronymed PECA. So this cookie law stops storage or access to information in end user devices, with some narrow exceptions, unless you get the user's prior consent. It's not just about web cookies, it also applies to information in mobile devices, connected gaming consoles, etc. So this means that if you are storing or accessing information in the devices of end users who are in the EEA, the cookie law applies. And in France, as I'm sure you know, the CNIL fined in the tens of millions of euros Amazon and Google recently under the cookie law, saying there was no one-stop shop. Here are some fines. There's a draft e-privacy regulation to replace the directive. It was meant to come in the same time as the GDPR, but there have been so many discussions, it still isn't in. Who knows when it will be in? And unfortunately, the UK will not be able to influence what it says because we are no longer in the EEA. So there could be a divergence. It will not apply to the UK, so we could have different rules regarding the cookie law in the UK and in the EEA. Legacy personal data I wanted to briefly mention. this is personal data of non-UK people, which was collected or received on or before the 31st of December. And you have to apply what's called a frozen GDPR to this, which is the GDPR at that date. If the GDPR changes in future, you don't apply that. If the UK GDPR changes in future, you don't apply that. So there could be possibly 3 regimes applying. And if the UK doesn't get adequacy, then probably essentially equivalent protection has to be applied to that data. Security, you've heard about the TCA mentioning Netscape and Mozilla Mail as modern email software. From a security perspective, of course, the worry is that it also requires the use of 1024-bit RSA and SHA-1, which are outdated, as you know. But I wanted to briefly mention something else, which is the NIS directive implemented in the UK via the NIS regulations. And this is about network and information system security. So some organizations have to comply with both the GDPR and this directive or regulations, which is about non-personal as well as personal data. And this has obligations regarding security measures and incident notification. So the EU recently proposed to update the NIS directive. Again, the UK is not going to be involved in that, so we could have a divergence in that area too. And those 2 examples, e-privacy regulation, NIS directive, they're just the tip of the iceberg. There could be a lot more areas where there's divergence and possibly 2-track laws and 2 sets of rules and 2 sets of legal systems to have to think about. And if you think that that graphic looks more like a tombstone than an iceberg, let's hope you're wrong. So thank you very much. That is me. And Field Fisher also has various blogs on Brexit if you're interested in that.
Thank you very much. Thank you very much, Quan. Excellent. In fact, thank you, Quan, Jane, and Mark for your presentations there. I think one thing we might have learned is that this is not nearly as simple as it all appears at first glance, which is not very, is it? But we've had some questions come in. We've got about another 5 or 10 minutes just to discuss a couple of these. I'm going to put the first one to Jane. We had a comment come in after your introduction. John Alcock asked, is there a period of exposure while we wait for new UK legislation to protect IP?
Oh no, it came in, the legislation replacing the community rights came into force on the 31st of December. So no, there is no gap at all. And actually the regulations, as far as possible, and this is provided for in the withdrawal agreement, requires us to provide, and under our own national law, as far as possible, equivalent protection to that which was provided under European Union law, where regulations applied. And of course, as far as things which were implemented in directives, that was primary legislation or secondary legislation anyway, from our Parliament anyway. So there's absolutely no reason why that shouldn't continue, and that will continue. And the final thing I should say is that the 2018 Act says that all the decisions of the Court of Justice, the General Court, and all the other EU institutions are still binding on us, unless the Supreme Court decides to depart from them. And if it does, it's got to use the same criteria by which it would depart from its own decisions or the decision of the House of Lords. And the final thing is that we're going to still take account of, the courts, including the Supreme Court, are still going to take account of decisions of the Court of Justice, General Court, and indeed the High Courts of the various member states. So as far as possible, it should be seamless, John.
Good. Thank you, Jane. One for you here, Quan, I think. You mentioned the mini one-stop shop. Gilbert Panter's just put a comment saying we have less EU customers than before Brexit, but find it impossible to get information from HMRC about what happens to VAT MOS.
I'm so sorry, I'm not a VAT person,
okay.
So I do not know what.
That's one we can pick up later then, Gilbert, so we'll do that one. This is probably one for you then, Quan. What form does the appointment of an EU data representative take? Is it just a letter or an email? Does it get registered anywhere?
Well, it does need to be something obviously that is you can show to the regulator if they ask for it. So you could letters probably better, but an email is not impossible. And it does depend on whether you're appointing as a representative somebody who is an organization which is an affiliate, like a subsidiary or a sister company. If you appoint a third party as a representative, and there are services coming up which say, hey, appoint us as representative and pay us and we'll be your representative. But then you might have more discussions about, you'll have to pay them. There might be discussions about costs, indemnities, and so on. It's a question mark about to what extent representatives can be enforced against, as opposed to just being used as a conduit to pass on messages to the data controller or processor. So, but yeah, it can, I mean, we at Field Fisher do have for clients a sort of simple 2 or 3 page appointment letter for representatives.
Okay, lovely. This might work for you, Jane. Paolo has said he's curious to understand what the legal position is regarding continuing to process and store data about EU entities in Britain without data privacy adequacy. What will be the effect of that?
Sorry, what's that question for me or for?
I think that's one for you, Jane, isn't it? Are you happy to take that one?
I will. I didn't quite catch it all. Can you just repeat it?
Curious to understand the legal position regarding continuing to process and store data about EU entities in Britain without data privacy adequacy.
I would imagine that it would be an infringement of our own Act, apart from anything else. But it would possibly also be an infringement of the regulation, and be quite. And then I would have thought that the regulators, if any other countries concerned, and this is what we just heard a few minutes ago, would, and this is a risk of double liability.
The follow-up question was, will there be any difference in how the European Data Protection Bill will treat controllers or process based in Northern Ireland?
Now that is interesting. So far as Northern Ireland is treated differently from the rest of the UK for some purposes. So far as, well, there's one intellectual property provision where it is very different, or two, I think, really. One is when it comes to geographical indications, and the other when it comes to something which is called supplementary protection certificates, which are a way of protecting utility of a patent by protecting an ingredient. But for all other intellectual property provisions are concerned, no. Northern Ireland is treated as, and the legislation, the acquired legislation, is the same as it is in the rest of the United Kingdom, except where there's a specific exception for Northern Ireland. As I say, I can think of these two, but I can't think of very many more. So far as Northern Ireland is concerned, I'm not altogether sure what their rule is as far as data protection. I know Scotland, the Scottish administration, the Scottish government had set up its own data protection administration. Certainly, I would have thought in that case the Northern Irish government would have power to do that, but whether it has done so, I do not know. I'm aware, because I've come across it in practice, of the data protection administrations in the Isle of Man and in the Channel Islands. But I would have thought that they're regulated under the UK Act. But again, I will check that out.
Thank you.
Brian, could I just chip in?
Yes, please do.
Paolo's earlier question about continuing to process and store data about EU entities, if it's EU individuals, then it's what I've discussed earlier on about transfers and legacy data, etc. If it's EU entities, i.e. organizations, then as long as it's not personal data, it's not affected by the GDPR.
Okay, thank you.
Yeah, and I should have made that clear.
Yeah, no, that's fine.
And I think Northern Ireland is covered by the UK GDPR. Again, it's a double checking point, but I'm pretty sure that Northern Ireland is covered by the UK GDPR.
Yes, thank you very much.
Thank you, Kwan. A little comment about you brought up cookies, Kwan. The default agreement to legitimate interest as the basis for processing personal data is often pre-populated in cookie policies. Is this allowed in the UK EU GDPR?
Very good question, which is often debated.
Thank you, Robin.
Yes, because of course, with cookies under the separate law, i.e. e-privacy law, you have to have consent. And the GDPR has, the UK ICO, I should say, has said, well, if you have to rely on consent, then you shouldn't be relying on legitimate interest because you need consent anyway. But that's not necessarily the view that everybody takes. And also, sorry, can I just check the question again? What was the specific question?
It was pre-populating. Hold on, I've dismissed it. Sorry. The question was default agreement to legitimate interest as the basis for processing data.
Okay, so a couple of other points. One is, there is a collection of the data. So can you use legitimate interest instead of consent to collect it? Because of the cookie law, you have to get consent anyway. But then there's a separate issue, which is after you've collected it, can you use legitimate interest to process the data after you've collected it? And most people think you can in that particular case.
Okay.
If that helps.
That's fine. Thank you. Can I bring Mark back in at this point? A couple of questions for you, Mark. First one's coming from Chiara. Can you expand on which Brexit trade and cooperation agreement issues impacting the back end are more easily automated and which ones are not, i.e. VAT, rules of origin?
I don't have that level of detail. Thanks, Cura, for the question, but I don't have that level of detail. I think what we found is that it's been around invoicing that's been some of the problems, but I think, I don't know if I could answer that question, I'm afraid.
That's not a problem. Now, Mark, I'd like to ask you one myself. So we just alluded to this at the end of your presentation. Are you finding from your customers that they're using this quite severe break in many ways of doing things as an opportunity to really accelerate their transformation? We've seen that.
I think two very related things have happened. I think obviously Brexit occurred, and let's assume that everything went swimmingly well for your organization. The shift of your workload will have changed. You'll now be doing more international things maybe than you were previously at a very simplistic level. And I think then maybe around the same time, depending on your perspective, COVID came along, and that forced everyone out of the office, and that stopped a lot of organizations to be doing processes where people were doing the process, not just managing the process. And it's a combination of those two that have not so much encouraged organizations to look at things differently, but essentially have forced them for their very survival to figure out how are we going to do things now. And some of that has been organizational change. And some of that has been, we just have to adopt automation. There's a lovely article actually in this week's Economist that touches on this very subject, both in the UK and elsewhere, where organizations are realizing that they have to take people out of the critical path of some of their processes, for want of a better way of looking at that. And the only way they can do that is with automation. So yeah, I think it's making that conversation a lot more often heard at the CEO level and not just within the walls of IT, if you will, or within the walls of the factory. I think people are going, things genuinely have to change. What does that mean for us?
That's interesting. Thank you. Business processes have basically been tested to the limits and then somewhat found wanting in probably quite a few cases then, by the sound of what you're saying.
Yeah, and it's across such a wide range of industries. I mean, it's very easy to sort of imagine some of the commercial processes, but also for a lot of our public sector customers, previously processes that may have happened in person, or you came into the local authority or whatever, people were involved in proximity to one another, and that was part of the process. All of that sort of pretty much ground to a halt. So for a large number of pre-existing processes that relied on that implicitly or explicitly, they've got to rethink those processes in a way that they're still comfortable still give people the right experiences, but are also still, you know, compliant and legal and can be readily regulated. So it's, for a lot of organizations, this is very far from trivial. And I think looked at wrongly, it's a cost, but looked at in the best way, this is an opportunity to take on efficiencies and a whole bunch of other things that I think could make a lot of organizations' lives easier, if not better.
Absolutely, thank you. Well, now we're 5 minutes over time now, folks. I've carried on with that because we had some excellent conversations there, and I'm aware there's 1 or 2 questions we haven't answered. So I'd like to make 2 more points. One is, I'm sure we'll have some more follow-up webinars around some of these subjects. Some of them need a bit more digging into. The one that leapt out of me was when e-privacy regulations finally, we know where we are. I'm sure there'll be a lot more things to discuss there. For example, the business transformation process is an ongoing thing as well, isn't it? No doubt there's more to discuss there. But can I ask you all for one closing remark about perhaps with the audience as to just where they could go for further details? I'm guessing, Mark, that you referred to quite a few interesting resources there on the SAP website from your point of view. Is that where you point people?
Yeah, so the simplest place to go is the SAP Notes part of the SAP website. So if you type SAP Notes into a browser or into a search page, you'll get there pretty quickly.
Lovely, thank you. Jane, where would you sort of direct people if they had further queries, which I'm sure there are many of?
Well, I think there will be rather less change than many people actually think. We are still going to be remaining in a number of international organizations. We're going to remain party to the World Trade Organization. We're going to remain party to the European Patent Convention and various other, the WIPO and party to the international IP treaties. I think that there'll be probably a practical pressure to move towards uniformity wherever possible. We know that if we diverge too far from the EU, that there are going to be consequences. That's something which was in the Trading Cooperation Agreement. We retain the right to do so, but unless a government really wants to put at risk vital interests, I think that we will probably in practice go along with the flow. And there's also, as I say, the tendency of generations of people to think and follow their European their European peers. So I'm hopeful that there will be at least a fair amount of functional similarity in the future. I know that there's a possibility of divergence, but I think that it's less a risk than many people suppose.
Okay, that's interesting. Thank you. And finally, Quan, I believe you do a regular blog on some of the issues you were discussing.
Yes, I mean, Field Fisher, not just me, on the Field Fisher website, or indeed if you just search Field Fisher blog, you'll find a lot on Brexit. And for my personal articles, etc., they're on or linked to on Quan0, the number, not the letter, .com for anybody. And of course, you can feel free to contact me on LinkedIn.
Okay, lovely. Well, look, that's been really, really interesting, folks. Thank you so much. There's clearly plenty more to discuss other times. I'd like to thank everyone for who attended today. Special thank you to those who put questions in. But the biggest thanks, of course, go to our 3 presenters. So Quan, Jane, Mark, can I say thank you so much for your input. This will be released as a video probably in a week or 2 on the BCS YouTube channel. So if you want to remind yourselves of any of the 3 good presentations we had, you can go there to do so. And can I say thank you very much for your participation, panel.